Hello, this is a follow-up video recording of our live virtual forum examining Haaland versus Brackeen that Cashew hosted on November 15th, 2022. So we're going to talk more with Shannon Smith of the Iqbal Law Center and Jessica Ryan, tribal attorney, and answer some of the remaining audience's questions. So welcome again, Shannon and Jessica. We're just going to dive in. One of the audience questions was, has the boarding school practices come up in these arguments, or will they? Because it feels like another attack on our children and families.
Yeah, I think that's a really important question, and I think ultimately the answer is yes. We know that historically that the impact of boarding schools has created trauma and has had an ongoing impact, and we know that it continues to be seen in the child welfare system today. We understand and recognize that it continues to have an impact in regards to the adoption industry, and certainly we would anticipate that it will continue and is a very important part of the discussion in regards to the implications of this case as well.
Jessica, do you have anything to add?
I agree with what Shannon has shared. The boarding school era is long. It's had a tremendous impact on our families all across Indian country, and it's something that we can't ignore. It's something that doesn't go away. It's a reality of what our families have struggled with over the generations, and so it is something that we are going to have to continue to address, and we need to address it in a good way. So yeah, it's still important and still relevant.
Okay, and the next question is something that we do hear frequently. An audience member asked, does making this not about race jeopardize the historic issues related to slavery and the removal of African American children from their homes at higher rates as well?
This is a really good question. Both race and the political distinction that Indian tribes have are significant issues, and it's really challenging to try to argue about whether this is a race or a political argument that is before the United States Supreme Court. It's obviously based on that unique political status of tribes. We talked at length about that during our initial time together. That is the distinction that is most relevant, and that's the distinction that's before the United States Supreme Court at this time. That doesn't mean that Indians don't have a unique race and a unique culture, and that also needs to continue to be addressed, just like the race of the African American or the Black community and other races. We specifically look to the American Indian community and the Black or the African American community because both of our communities, when we look from a racial discrimination lens and a racial categorization lens, both of our communities are disproportionately represented in national statistics, in state statistics in Minnesota, and that statistic is consistent in many other states as well. So that racial distinction also makes an important distinction, and we need to continue to work on what we do and how we do as it relates to families in child protection cases. Race does matter. What we have here, though, is a different political categorization, and that also matters and has a different legal significance in these kinds of cases.
Okay, thank you. So another audience member asked, I heard quite a bit of discussion surrounding the third placement preference. Could you summarize the arguments in relation to the third placement preference?
I think the important piece of the third placement preference is to have an understanding kind of the context of why it matters. So the third placement preference that I assume is being referred to in this question is the placement preference that if children Indian children can't be returned or placed in the care of their family, that they're placed with other tribal members. And if they can't be placed with other members of their same tribe, that they're placed with other members of another recognized tribe. I think we have an example in Minnesota of why this is so important. Is, for example, the Minnesota Chippewa tribe, and there's unique bands. We have, for example, the White Earth Band and the Leech Lake Band. While they are distinct bands of the Minnesota Chippewa tribe, oftentimes because of family connections and tribal values and customs, that for a child to be placed, maybe with a member, a child who is a member of the Leech Lake Band, and for example, may be placed with the White Earth Band, they're continuing to have a connection to their community, to their tribal values and customs. So it has value in regards to having children connected and honoring their identity in totality. And so it has some great significance in regards to kind of some of the the questions in the context. There were some hypotheticals that were somewhat difficult because they were just not so practical in regards to how it plays out in reality. So I definitely think that it has value and importance, and we see, practically speaking, why it matters and why it works. For example, in the area where we're working in Minnesota.
Thanks, Shannon. And then our last question is, can you discuss more about who should make the decision of the child's welfare? To me, honoring tribal sovereignty means honoring the tribe's decision if the parental rights are terminated.
Thank you. That's another good question. We all know, as we discussed in the prior time where we were together, that the Indian Child Welfare Act is an act that gives preference to tribes being able to make decisions regarding their families, regarding their next generations. Sometimes we refer to it as a jurisdictional statute because it's clear that the intention in the federal statute is to transfer jurisdiction to tribes so that they can make those decisions regarding their families and their future. So bearing that in mind and looking at the other provisions that are set forth in the Indian Child Welfare Act, it's very clear that the cultural standards and the values within that particular child's tribe is what is intended by the federal government to be applied in making decisions regarding children and their families. And so it only stands to reason, with those as policy directives from the federal government, that once there is, in this instance, the question has been asked with regard to after following a termination, it's appropriate then to have the tribe involved in making those decisions for the next steps. So if the state's able to make sure that the tribe is a party to the proceedings and they can participate in those decisions, I've seen it very effective where the county worker or the state worker in other jurisdictions has partnered with the band, the tribe, or the nation, and they have given deference to the decision and recommendation of that particular child's tribe, band, or nation regarding next steps. And that seems to me to be most in line with what the law sets forth and also with what the spirit and the policy of the law are, at least from a court perspective and a process perspective legally. And Shannon, did you want to speak to that as well?
Sure. I think one of the things we know in Minnesota, we have through the Minnesota Family or Indian Family Preservation Act, we know that by statutory definition, the best interest of an Indian child really honors their connection to their family and their tribe. And as we think about these cases, I think it's also really important to recognize that as a case closes, so if we have a child welfare case, ultimately the case will close. And the social worker, the guardian ad litem, that their role in that family's life really ends as a case closes. And ultimately, it's the tribe and the family that for the duration of that child's childhood are continue to be involved with that child and are making decisions and honoring who that child is. And so as we look at best interests of that child and for generations to come, really honoring the voice of the family, elevating the voice of the tribe are critical in regards to the long-term best interest of that child, and really truly honoring that who that child is and their connection to their culture, their community, to their identity, and ultimately to their family and their tribe. And so just kind of some context in regards to, while it was jurisdictional, why it is so very important in regards to making sure the voice of the tribe and the family are honored and protected.
I think that's a good note to end on. Thank you, Shannon and Jessica, so much for your time.
Yes, thank you.
Thank you. Onewe.